session. We were able to bring the two workshops together. Thank you, Carl, for your flexibility in moving this. This was the morning originally. We moved it to the afternoon so that everyone could participate here. Two quick program notes. I mentioned them, I think, when we only had the one workshop in here. So first, we have a collaborative note-taking document. If you go to Rules as Code, there's a link at the top. So you can click on that. You'll see the description of the panel, but also an opportunity for someone to be awesome and take notes of the panel, and then for anyone to drop questions in, comments, concerns, and that way we can take the benefit of this conversation and share it around the world, and all the people who are working on it, but we can't make it here today. We're going to proceed in 3 20-minute-ish parts. First, we'll have introductory presentations from me, and then down the line. Then we'll have questions for the panel. I'll try to rely on the questions that you put into the collaborative document. And then third, I'd like to do a little bit of a flipped Q&A. So we have representatives from the government of Canada here who are working on a pilot project on Rules as Code. And so they have many questions for the smart people in the room here to help them along their way. So we'll do a little bit of a flipped Q&A, asking you guys the questions and then seeking your insights. I'll begin. My name is Jameson Dempsey. I'm a residential fellow at Codex, which is the Stanford Center for Legal Informatics. I'm also a global director of Legal Hackers, which is the largest grassroots legal innovation community in the world, with 150 chapters around the world, including a couple of chapter leads here in the room today. Previously, I was a practicing regulatory attorney focusing on telecommunications and technology law in Washington, D.C. and in New York City. Today, I'm really excited to welcome panelists from Singapore, Australia, and Canada to discuss the emerging Rules as Code movement. It's a global community focused on deploying public computational law systems within and in partnership with legislative and rulemaking bodies. The Chief Information Officer of Estonia has called legislation as code the most transformative idea that emerged from one of its recent Digital 5 national conferences. The idea of rules as code is relatively straightforward. As the New Zealand Service Innovation Lab envisioned in its 2018 Better Rules for Government report, in an ideal future state, multidisciplinary teams of policy analysts, legislative drafters, service designers, and software developers would co-design policy and legislation such that the result of the policymaking or legislative process would include both human-readable and machine-consumable enforceable legal rules. Public agencies and private actors could then build products and services on top of these rules and through publicly accessible APIs. In their view, this approach would result in born digital legal rules that are more transparent, predictable, and measurable, and would enable better government service delivery, including through government-developed and third-party developed applications. It would also enable legislators, regulators, and the public to test the impact of regulatory changes before they are adopted, and of course after they're adopted as well. From a business perspective, more predictable rules may increase the attractiveness of investment in countries with rules as code, as Will Reinhart of the American Action Forum, a free market think tank in DC, posted on Twitter just 3 or 4 minutes ago. While there's significant prior art in this area, including from many people here in the room, that's why we want to source your intelligence on these issues, there are a few aspects of this movement that stand out, at least to me, as unique and promising. First, the Rules as Code movement is emerging not only from the legal informatics academic community, but also from the world of open government and service design. As such, there's a focus on rapid prototyping, testing, and iteration, often using free and open source tools such as Python-based OpenFisca and DocAssemble. In my view, this could catalyze significant activity as hackers, hobbyists, and lobbyists, and in-house innovators working in the open begin to take a stab at turning law into code. Second, the Rules as Code movement has government support. As many of you know, open government communities are springing up around the world and taking the form of government innovation labs, including things like 18F in the United States and the US Digital Service. Here in Canada, the Canadian Digital Service, but there are examples all around the world. And at least 2 of them have been, well, at least 3 of them have been working on Rules as Code, including the ETA Lab in the French national government, and in addition, the New South Wales government and the New Zealand Service Innovation Lab have been pioneers in this space. Third, Rules as Code strikes at the process of lawmaking and regulation. As such, in addition to thinking through the substance and presentation of the law, Rules as Code will require law and rule drafters, the legislative office, to work and think more clearly about the logic and outcomes of law, and to develop new skills and work alongside new collaborators, including software engineers and service designers. Of course, the impacts are not just in the back office. You can imagine politicians, lobbyists, and think tanks all leveraging rules as code to jostle for specific legislative and regulatory changes. Fourth, the movement is global and growing rapidly. Several conferences and convenings, including this one, have explored rules as code. In fact, the 2019 Commonwealth Association of Legislative Council, the Conference of Legislative Drafters, recently explored this topic in Zambia. There was recently also a Rules as Code show and tell. If you went to rulesascode.org, you can see all the videos. We had 17 5-minute presentations from around the world of people working on this. Now, of course, there's a lot of promise here, and it's very exciting, but there are also a number of challenges, and this is all very new. So I'm going to highlight, just in bullet points, a few of the challenges that we can talk about in more depth in the presentation. First, there's an R&D awareness challenge, namely the disconnect between this community here in the room and the global Rules as Code community. Many of the folks in the Service Innovation Labs are unaware of this conference and that this is happening. That's a challenge because there's been decades of work here that's been really promising, and we don't want people to make the same mistakes over again. We don't want history repeating itself where mistakes have been made, and we don't want people reinventing the wheel. Second, there's a human-centered design challenge. Specifically, there's a need to identify and figure out how to meaningfully include key stakeholders in this process, including members of the public and entities impacted by new laws and regulations. The hope is that by doing so, it'll transform compliance operations and public access to an understanding of law and legal process. Third, there are technical challenges with rules as code systems. I'll leave that up to some of our panelists to discuss. Fourth, there are political and legal challenges. There's a big difference between a government innovation lab running a pilot and a legislative or regulatory body enacting rules as code, and we're a long way off, especially where some legislators we know don't even use email. And there may be political headwinds to this process altogether. Finally, there are software development challenges, namely who should be building rules as code, the private sector, the public sector, some mix of both. And while commercial teams have perhaps been more successful at developing and deploying public computational law systems, there's a real risk of regulatory capture, as David mentioned this morning. In fact, some tax preparation companies within the United States recently lobbied for an amendment that would have prohibited the government from offering free tax preparation software. The amendment was dropped, but the fact that it was introduced, I think, speaks volumes. Sixth, there's a broader question about whether formalizing prescriptive rules-based systems in government is the right approach at all. For example, there's a growing call for more adaptive outcome or risk-based regulatory systems that rely on data and machine learning to achieve goals in a more flexible way than existing complex regulatory apparatuses. One example here is in spectrum management, where adaptive spectrum management has been proposed and lobbied for in the 5G context. So with that, I'd like to turn it over to our other panel members for their introductory remarks. Each will have between 5 to 10 minutes. I'm going to start maybe with Scott. Yeah, from Transport Canada. So I'm going to plug this in. Yep.
Okay, so I'm Scott McNaughton. I'm with the Canada School of Public Service.
And Juliette Bastien with Transport Canada.
So we just recently started a discovery project with Rules as Code. So we're going to give some context and some introduction to what we're doing. Should I control the slides? Or? Yeah. So we just want to set some context for what regulators are facing today and why this is now emerging, at least in the Canadian federal government, as something that we're looking into. And then we want to set some context about the Canadian legal and regulatory framework and how we see rules as code fitting into that, and some of the legal and procedural challenges, and give you also some insight into the actual discovery work that we're doing. So we'll start with just an introduction of who we are. So
I work for Transport Canada. I'm a policy advisor. And Crispr Canada is the federal department that has a mandate to ensure a safe and secure and efficient and environmentally responsible transportation system in Canada. And we're responsible for the Government of Canada's transportation policies and programs. And what we do is we develop legislative, regulatory, surveillance, and enforcement activities. So we are the regulator, so we are the rule maker in terms of transportation. In 2016, we recognized as a department that we were not keeping pace with changes that are happening around us. So we embarked on an ambitious transformation plan, which I'm working under Transformation and Transport Canada. So the aim of the plan was to rethink how we design, how we deliver our programs, and how we do service delivery. And one thing that's interesting with rules as code is that the rules that we are looking at for us, for Transport Canada, they're not in legislation. They are more, but they are not in law. They are in regulations, policies, and guidance. So it's more about process for us, and obviously the authority is in the Act, the authority to do those regulations. So that's about.
So, and I'm from the Canada School of Public Service, which is an interesting organization. So we have a mandate to build capacity within the public service, for lack of a better word, to teach people things through learning opportunities, events, that sort of thing. But lately, we've been taking advantage of the part of our mandate, which really focuses on the learn by doing. So, you know, we've come to the realization that sitting people in a classroom and trying to teach them stuff only goes so far, and if we're being honest, probably not that far at all. And so now it's about, can we partner with departments who are looking at new and emerging technologies, and can we process that into a learning opportunity for those departments and for those functional communities like regulators, like drafters, as we work on that problem together. So when we look at the Canadian context, what we see is a very complicated regulatory situation. So there are over 2,600 federal regulations and probably thousands more at the provincial, territorial, and municipal level. Right now, to really do any sort of analysis of that regulatory stock for any reason, let alone rules as code, is an incredibly manual, analytical process, prone to human error and prone to mistakes. You know, a lot of our work in the federal government is still paper-based. It's still resource intensive, and really, like, we're not doing anything to link our data to concepts like regulatory burden, to regulatory outcomes. And so we're dealing with an analog system that's trying to exist in a digital world. And obviously that's not good enough anymore. If you want to add anything?
I think no.
Okay. So just to set some context of rules as code and why we're doing this. So we want to make government easier for people and businesses. It's one of the core concepts of trying to create a more citizen or business-centric approach to how government delivers services. And at the end of the day, even a regulator, even an inspector going out to a business and trying to find if everything's compliant, that's a service that they're providing. You know, they're not out there to be a police officer and catch all the bad guys. They're there to provide a service both to the business that they're inspecting, but also to Canadians in general. If we make sure that, I'm sure many of you flew in today, so if we made sure that your airplane was safe, that's a service to you. It makes sure that your airplane's not falling out of the sky, that the crew is properly trained and equipped for every situation that could come up while you're in the air. So really that whole rule making and rule enforcing process is a service. And we're slowly in the Canadian system coming to that realization.
I'm kind of confused, sorry. We don't know what that's like. Yeah, so I think, yeah, one of the things we wanted to do at Transport Canada is we have so many rules and we have so many services, as Scott was describing, that we realized that by transforming, you know, do we want to transform and use technology to see how we can better deliver to users. So one thing we were thinking of is looking at Rose's code, and it's what we decided to do with the different partners. And so the assumptions for us behind Rose's code at Transport Canada, and only based on what we've read, because we haven't started our discovery project yet, is we think we will be able maybe to implement a program through the Rules as Code project, because it would enable us to use digital means to determine eligibility or calculations and things like that, because at Transport Canada we deliver a lot of certificates and licenses, so that could be for the user easier for them to get a license or certificate. We also think maybe that we'll be able to develop virtual agents like Alexa, Google, something like that, to help people navigate the rules of government, especially Transport Canada's rules. So we were thinking maybe people will be able to ask Alexa, I just bought a 10,000-ton boat. What do I do? Do I need to register it or whatever? And it will be able to tell the person what to do. Also, we think it might be able, eventually, we'll be able to provide stakeholders all the rules, and they can integrate them into their own processes and programs to ensure that they are more compliant and they are compliant with our requirements instead of an inspector going and checking everything. And finally, also, we think it would support open government, because it would provide, we would be able, our intention is to provide eventually open source code, so people can use it, third party can use it, and they can create, for example, an application, and that could support our programs and our services, because again, people could use that and be more compliant. So yeah, that's my.
Okay. And so this is very early days. So we have kicked off a project with an extended team that has very diverse representation across government. So we have drafters, we have lawyers, we have policy people, regulatory people, technical people like developers. So the team is coming together. So these legal considerations that we've thrown up are some very early day questions that, in consultation with the Department of Justice here in Canada, that we've come up with as questions of, they're asking us, how does this apply? So, official languages, of course, Canada has two official languages, French and English. Both are considered official, and all laws, regulations have to be drafted in both languages simultaneously and more or less be interpreted the same. So how does that interact with the concept of rules as code is something that we have a question about. Drafting conventions in Canada are embedded in our Constitution and also in legislation itself under the Official Languages Act. So actually changing how we draft our legislation, how we draft our regulations is not as simple as just updating a process or updating a policy. That's actually embedded in the law of the land. At the federal level, we have a lot of legacy software that helps us draft, especially English and French simultaneously. So we're curious about how anything new introduced is going to integrate with that software. And then lastly, we use a lot in our regulations a concept known as incorporation by reference, where we'll actually refer to a standard or another Government of Canada document, usually Government of Canada documents, sometimes international documents. So you don't get a full context or full understanding of that piece of legislation or of that regulation unless you go refer to the document we're referencing. So one of our documents could reference, I don't know, ISO 9000, for example. Well, okay, so our regulation has been coded, but ISO 9000 has not been. And what does that create for the interaction that a Canadian might have with a machine-coded piece of legislation or regulation? So thank you very much. We tried to keep it within 5 minutes, but we might have gone a bit over.
Thank you. All right, let's get the next presentation up, which is how do you want to do this? Do you want to just
probably, no, I probably could just place with Scott, if that's okay.
Yeah, Scott,
Yeah, working. Okay. I'm Nick Hamid. I work for DAO61. I'm team leader of the Business Process and Legal Informatics group, so we thought it was kind of fitting in this kind of context here. Basically, what we're doing is anything related to digitalization of legislation. So how can we ensure that compliance of individuals and businesses is actually guaranteed? Now, as we all know, compliance is not the easiest thing. So if you look from a business perspective, first there is the regulations that are being drafted by government. Lawyers have to look at that. Then organizations have to come up with their business process that has to be guaranteed to be compliant to those regulations. Then they have to build their software to support their business process that have to be compliant to all those regulations again. Then they are executing those business processes, and at the end of the year, there's going to be an IT audit that is again checking whether they have been compliant to all those regulations. And whenever there's any kind of change to a regulation that even remotely touches the business process of that organization, we are just going to repeat this process. But it's going to be a very long, difficult, tedious process. And if you compare that to the hourly rate of the average lawyer, that you might be aware of, this is what we end up with. So if you look at those numbers, that is actually scary. This is ridiculously expensive. If you do this for every single nation, and you have to do this over and over again, if you look at that, 15 to 20% GDP, that is a massive amount. So if we make an efficiency gain here of 1%, that is still a massive amount of money. That is actually worthwhile to go through that. So even at the time it was President Morrison, then in the meantime he became Prime Minister Scott Morrison, and well, we changed in Australia every 6 months of Prime Minister, so it's a bit hard to do. I think at the moment he's neither. But you already pointed out that legislation as code is probably the holy grail, and we should actually start write legislation from that perspective to already take that digitalized approach to make sure that we speed up that process going from initial idea, draft the legislation, check it, make sure you have a business process compliant with it, and then go through that process all over again. So based on the experience that we've done, we can save up to 30% of compliance costs, which is like 5% of GDP. I mean, that's massive. I mean, unless you're a Zimbabwe or something, if you're a Western country, that's a lot of money. So the idea is that we come up with a sort of formulation of legislation that is sort of a meet in the middle way. So it's not full-on technical Java code, but it's also not the complete natural language that is very verbose and hard to understand for a machine. We want something that is right in between, that is both machine interpretable, but still understandable by lawyers, computer scientists, and anyone in between. So that's basically what we advocate for here, that we have a formalized representation that can be used to generate your processes, that can be used to check your processes, and that can also be used by legislators to check whether that is indeed still representing what they intended with the law that they provided. But the idea of legislation as code is already slowly taking off around the world. So we have a few locations, among which was Canada, that already started to experiment with this. So it is something that slowly starts to take off here around the world, and hopefully we are, actually starting the movement to spread this across the globe. Now, as Data 61, we have something called regulation as a platform. So we have already started this to make sure that this entire process from legislation to ensure that we can actually look up legislation, we can make those connections, we understand what the legislation is about, we can check our compliance. That we have an entire framework that covers all those aspects. And part of that aspect, obviously, is to make sure that legislation is represented in a formalized way. Because only then we can actually automatically check whether any single individual, organization, or governmental institution is compliant with the laws that have been set out for them. So just to give you a bit of an idea, we are working and have been actively working on different components, and I think in terms of time I'm not going through all of those, but we have already a reasoner. So we can already formally prove that a process is compliant. We can already generate processes based on rules and regulations. So from that perspective, we are already there. The part that is really important now is how do we go from that old-fashioned plain English, at least for Australia's plain English, formulation of legislation to a more machine understandable format. Thank you, that's my hand. That was very much, right? Yeah, that was perfect.
Yeah, well, the system's like that. Get the turn on American mode because I've got speaking.
Yes.
So I'm getting you solved again to make sure that the order is made.
Yeah.
I'm just going to drag it. Here, do all that.
As a reminder, we have the collaborative document. I see someone's typing notes. Thank you so much for doing that. If you want to put in any questions or comments, that would be really helpful.
All right. Can you say again where it is?
Rulesascode.org. And there's a link at the top there to get you the list. Otherwise, you're going to be looking at the show.
All right. So I'll try and get through this as quickly as possible because I think I'm repeating some of the things that other people
how you arrived at the answer. And so maintaining support for isomorphism in our contract language and our